Federal agents say they stopped millions of dollars of hard drugs from hitting the streets. The feds making that announcement just a few hours ago.
The day began as a typical morning in Georgia, when a black SUV was stopped along the border of a silent county road just beyond the reach of Atlanta. However, inside the car, authorities discovered 2 pistols, $48,000 in currency, and an item that was much more alarming, which was a closed envelope bearing the printed name of a courthouse clerk. That specific envelope would spark one of the most volatile corruption inquiries in modern American history, extending far into legal chambers, police precincts, and criminal organizations spanning 7 different states. The name written on the packet directed detectives to a workstation that had rested silently under the harsh fluorescent glare of a Georgia tribunal for many years. Nobody had ever paid much attention to the woman employed there, as she was merely a fixture of the scenery, a clerk who managed timetables, organized arrest records, and moved legal folders from one office to another. Her position was designed to be inconspicuous, yet the evidence inside the envelope revealed a narrative that was entirely contradictory. When the FBI commenced its quiet assessment, agents realized they were investigating an individual whose electronic footprint ventured into areas where no judicial staff member should ever go. Their initial demand was for entry into the court's administrative software, specifically targeting the internal history, the saved backups, and the hidden metadata, rather than just the public-facing documents. Within a few hours, alarming anomalies started to appear, as scores of case dossiers were unfinished, with some lacking concluding pages, while others displayed odd timestamps indicating changes made moments before sentences were voided or bails were posted. A specific file was stored under 3 distinct aliases, each listing a separate judgment, even though they all referred to the exact same accused individual. Detectives located case identification numbers that were present in physical files but were completely absent from the digital database, while other records had been copied, redirected, or entirely revised. What first seemed like standard administrative errors started to adhere to a specific design, as the folders most likely to lack information were all connected to drug trade indictments involving heavy cargo seizures and complicated shipments between states. Although they looked haphazard at first glance, underneath the surface they were linked by specific schedules, techniques, and authorization autographs. Analysts from the Bureau began comparing case archives with the usage history associated with specific employee logins, and one particular profile showed up repeatedly. It was the account of the very clerk identified on the envelope, and her passwords had been utilized to access secure archive vaults, open protected legal files, and modify the calendars for dangerous suspects. Throughout a 3-month period, she accessed the network outside of business hours on 19 separate occasions, and the majority of these logins continued for under 10 minutes. This was just sufficient time to modify a case condition, delete a tracking marker, or generate a movement order, leading the FBI to believe she was likely not operating by herself. They broadened their scope to encompass every person within her clerical department, and that is the moment when the magnitude of the situation grew significantly. Through an examination of banking statements, detectives found that 4 staff members, comprised of 2 administrators, a guard, and a deputy bailiff, had accepted undeclared transfers from firms based in Delaware and the Virgin Islands. These payments were categorized as advisory charges and varied between $8,000 and $37,000 for each occurrence, happening on a consistent schedule that typically followed the day a lawsuit was settled or a delivery was approved. None of the individuals receiving these funds had declared any secondary jobs, and the common thread connecting them was not merely the currency, but the specific timing of the events. On a Friday during March, a specific worker got a digital transfer marked as a first-quarter retainer less than 12 hours after authorizing a release form for a truck transporting confidential drug evidence. That truck was subsequently declared lost, as its location beacon had been disabled while it was on the road, and no accident report was ever submitted. The entire event was dismissed as a logistical holdup, and on that very day, the clerk who approved the itinerary signed out of her workstation at 3:12 in the morning. This logout time was fully 3 hours past the end of her scheduled duty, and as these incidents piled up, the Bureau's specialized mapping unit constructed a chronological sequence. They assigned specific colors to each questionable lawsuit, financial transaction, and record modification on a large board, and by the third week of study, a distinct pattern started to emerge. The diagram revealed a web of operations that functioned in synchronized loops, with each rotation involving the chambers of a judge, several clerks, delivery guards, and a remote warehousing location. These loops continued for 2 or 3 weeks at a time, invariably ending with either a finalized lawsuit or a lost piece of property, proving this was not careless graft, but a sealed machine operating under a public tribunal. One of the most alarming revelations originated from a neglected storage room located beneath the southern section of the structure, a space intended for holding secure displays and old dossiers. However, when investigators examined the room, they discovered 6 cartons marked for evidence elimination that had never been officially logged as having arrived at the facility. Contained within were taped packages of drugs, stacks of money, and electronic hard drives, many of which corresponded to records from lost property lists in nearby jurisdictions. Other objects possessed no tags whatsoever, and the entry register nearby was even more concerning, as it recorded numerous visits by people whose jobs had ended months prior. Camera recordings verified that the area had been accessed at least 7 times in a fortnight by people dressed in street clothes who were utilizing restricted security passes. Crucial testimonies were postponed, tracking paperwork disappeared or was marked as unfinished, and one record claimed a suspect was detained when video proof showed he was never processed. At this juncture of the inquiry, agents from Homeland Security and Immigration and Customs Enforcement were invited to join the team, tasked with following money trails across state and national lines. Within a few days, they exposed a scheme involving shell corporations that directed money through minor investment groups, property trusts, and advisory agencies. While the titles varied, the movement of capital stayed consistent, with foreign money coming in via Caribbean banks, moving through middleman ledgers in Florida and Texas, and ending up in personal savings owned by court staff and local police. One such dummy corporation had lately purchased an industrial depot on the fringe of the Savannah Logistic Zone, while another had obtained property in southern Illinois featuring cold storage lockers. Neither site was registered to any known suspect, yet both locations displayed utility usage linked to wrapping equipment, chemical stockpiling, and encrypted internet hubs. The Savannah depot had never applied for commercial permits, but electricity consumption surged on the specific evenings when truck shipments were designated in legal records as secure transfers. At both sites, officers would eventually discover schematic drawings indicating delivery points, video of men in combat gear, and task lists written in both Spanish and English. This operation was not merely about transporting narcotics, but rather about constructing an alternative infrastructure where judicial power was for sale, files could be altered, and property diverted without detection.
During this phase, certain detectives still wished this was a contained incident. But that hope was destroyed when they found a sketch hand-drawn on the reverse of an antique court register. It displayed paths extending from Georgia to New York, across to Texas, and down towards Miami. with red asterisks indicating delivery spots and blue ink outlining transport loops. A handwritten message at the base of the page stated that the system would reset in 12 days, and amidst this rising pressure, a single internal note prompted profound contemplation. A supervising officer questioned in writing that if such events were occurring in one tribunal, how many other locations might be corrupted. This was a terrifying inquiry that paved the way for a deeper level of scrutiny, extending past Georgia and the initial envelope to consider a nationwide web concealed by lawful documentation. By this time, the FBI had also connected a court assistant to a distinct immigration fraud investigation in New Jersey, where a phone number was flagged for registering a consultation business in Newark. That identical phone number was subsequently utilized to request a parking permit at a Georgia courthouse, indicating that the syndicate likely employed common assets across various regions to align trial dates, witness transport, and police protection. This revelation sparked a strategic argument among the agents regarding whether they should execute arrests right away or delay action to uncover more components of the ring. Some cautioned that striking too soon might startle the suspects into vanishing, whereas others contended that waiting longer increased the risk of critical evidence being annihilated. In the end, they chose to proceed with stealth, and the Bureau started organizing what would turn into one of the most intricate multi-state strikes in recent history. Targets were pinpointed, arrest orders were written, funds were locked, and the roster of accused individuals expanded to include 21 policemen, various clerks, and civilian vendors involved in state agreements. Prior to the commencement of the raids, federal leaders met in a protected facility to synchronize their tactics, studying architectural layouts, positioning areas, electronic gateways, and possible threats. An event that began as a simple roadside check in Georgia had transformed into a synchronized assault spanning 7 different states, marking not the conclusion of a file, but the start of a cleansing. Are you surprised that such events transpired within an American tribunal? Or do you suspect that more profound conspiracies are still concealed in other regions? The upcoming segment will detail how federal agents attacked nationwide, revealing not merely crime, but a meticulously engineered framework hidden under the justice system itself. Identities emerged in rapid succession, with some originating from legal archives, others from police schedules, and a handful from pension rolls that had been discreetly modified recently. 21 individuals, each possessing immediate links to policing or court functions, were now targets in a federal felony inquiry. Although their specific duties differed, their objective was identical, as they had assisted in transporting narcotics across America unseen, not by evading the authorities, but by integrating with them. Included in this cohort were 14 licensed peace officers, some of whom were currently active, while others had resigned months prior to take jobs in private protection or advisory sectors. Each one of them had at some point worn a badge, and some still possessed them, but federal probes indicated they were employed by a syndicate functioning across state borders and within the U.S. justice apparatus. 2 of the most prominent figures were serving sheriffs, Milton Gaston from Washington County and Bruce Williams from Humphreys County, both of whom were elected leaders sworn to defend their populations. These 2 men were now alleged to have utilized their power to ensure that illicit drug cargoes moved through their territories without any hesitation. Detectives traced their participation by employing a mixture of physical observation, banking analysis, and the interception of their private messages. Sheriff Gaston had approved specific police guards for the movement of evidence, yet those vehicles never arrived at the storage facility and were instead seen turning onto rural paths before being discovered vacant.
Sheriff Williams had provided provisional entry cards to workers from other states who were absent from official logs but were subsequently captured on video accessing restricted zones of the tribunal. As the inquiry probed further, the overall scenario became increasingly alarming, revealing that these were not trivial violations, but orchestrated maneuvers meant to safeguard cartel deliveries masquerading as police missions. On at least 9 distinct occasions, police personnel had supplied immediate armed protection for trucks transporting money, drugs, or both commodities. The caravans employed official cruisers with active lights and adhered to standard driving paths to evade doubt, while officers drove in front to secure junctions and spoke in code over encrypted frequencies. Their involvement made it practically impossible for regular patrols to interfere because the activities looked entirely sanctioned. Body camera footage from an unconnected traffic stop captured a drug truck passing by with 2 police vehicles leading it, and the filming officer had no cause to detain them since it appeared to be a standard internal transfer. Beyond providing armed convoys, numerous officers were connected to the fabrication of search warrant documentation. Investigators discovered 3 specific warrants that had been altered after receiving a judge's signature, with edits that deleted locations, modified descriptions of items, or added new rationales absent from the initial versions. These modifications permitted syndicate members to transport product through checkpoints without initiating legal disputes, and one document filed in Texas and reused in Georgia was signed by a cop who was on holiday at that moment. That officer's identification number was utilized once more during the subsequent month for a completely separate matter. Video surveillance from inside the courtroom exposed yet another tier of deception, showing officers in 3 different locations exchanging evidence pouches after the building had closed. The containers were retagged, closed up again, and entered back into the database with fraudulent chain of custody logs. And when the original contents were traced, agents found they had been substituted with fake materials or weighed down to equal the recorded mass. Monitoring operations in 2 states captured off-duty police cruisers sitting outside storage depots that had earlier been marked as questionable. One site in New Jersey was being watched after a delivery of chemicals triggered alerts at a harbor, and a month later 2 indicted officers were observed leaving that structure carrying sealed boxes. No warrants had been requested for that visit, making it obvious that these people were not acting by chance, but were components of a larger apparatus. Duty rosters from 3 separate counties displayed synchronized timetables among the officers, featuring traded shifts and aligned vacation days. A sergeant was placed in Georgia, Florida, and New York within a 10-day span without filing travel expenses, yet bank records showed hotel bills, gas payments, and rented encrypted phones, consistent with secret collaboration. Federal agents eventually recovered location data from department radios, and the travel habits corresponded with known cartel shipping lanes, passing through various towns at set times that matched evidence room changes or court closures. It was not merely that the officers were assisting, but rather that they were managing a duplicate logistics branch within the government hierarchy. A warehouse utilized as a repacking hub had been guarded by private firms employing expired police credentials, and their access had been sanctioned through falsified papers processed by a local sheriff's department. The padlocks were bought with public money, and security cameras were turned off using internal passcodes. And when the FBI stormed the location, they discovered case folders piled next to drug wrapping supplies. Every binder bore the official stamps of the courthouse, yet was completely absent from the electronic record system. Maybe the most startling piece of information came from a testimony where an officer told federal agents upon being detained that they were assured the entire operation was lawful. He stated that they were informed the judge had sanctioned it, and that solitary phrase sent tremors through the investigative group, even though no direct proof has yet implicated a sitting judge.
The suggestion created fresh anxieties regarding the reach of the network, although federal attorneys have stayed prudent in managing this allegation, and currently no judges have been charged. Nevertheless, detectives are examining thousands of internal texts, meeting minutes, and security logs to verify if any judicial authority knowingly aided or hid the scheme. As public awareness increases, law enforcement leaders in the area face demands to react, with departments suspending accused officers and courts starting internal audits, while federal bureaus prepare for more indictments. What distinguished this case was not merely the quantity of narcotics or the count of detentions, but the understanding that for years individuals sworn to enforce the law were actively sabotaging it. They were not corrupted by external bribes, but were integral components of the system who escorted, falsified, deleted, and shielded the criminals they purported to battle. This provokes a query many are asking, wondering how many other officers were complicit but remain unnamed, and how many tribunals nationwide are susceptible to this identical mode of graft. How does one rebuild faith in the community when the treachery originates from behind the badge? In the upcoming section, the narrative grows beyond personal culpability as thousands protest, attorneys construct massive cases, and the state faces a crisis of faith in the justice apparatus it relies upon. News traveled faster than authorities could address, and in Georgia, mobs started to assemble outside the very courthouse where the hidden vault had been found. Citizens congregated with placards, mobile devices, and inquiries, not screaming about narcotics or guns, but insisting on knowing why their legal system permitted such events. By the third day, the demonstrations had spread to adjacent states, where residents in Mississippi and Tennessee positioned themselves in front of police stations and halls of justice. Many of them had once trusted the individuals now under scrutiny, and some had cast ballots for the sheriffs facing federal accusations, while others had dialed these officers during emergencies without knowing the truth. The factor that intensified the rage was not merely the deceit, but the quiet that ensued, as for years people had guessed something was amiss when files vanished or accused persons went missing. Narcotics deliveries were reportedly incinerated, yet nobody ever witnessed them burning, and now those whispers seemed like disregarded cautions. As federal agents divulged more identities, local leaders started to react, and several sheriffs convened media briefings to declare they were stepping down. Some claimed ignorance of the graft, while others confessed they had neglected to move on initial indicators, and one police guild released a notice saying it would cease defending officers who breached public confidence. The signal was unambiguous, as nobody wished to be observed supporting the defendants, while behind the curtain, prosecutors were already constructing the subsequent phase. With over 20 individuals indicted and more captures anticipated, legal squads started analyzing possible charges, considering crimes that were far from minor. They looked at trafficking, hindrance of justice, misuse of position, and fiscal plotting, but the accusation holding the most gravity was the trafficking of humans. Certain officers and assistants under scrutiny were blamed for assisting the movement of more than simply drugs, as evidence now hints that specific vehicles transported people across state borders using the same shielding methods. This drastically changed the mood of the investigation, shifting it from theft or payoffs to the buying and moving of lives under the pretense of judicial power.
The trafficking allegation invited instant strain from support groups, and human rights bodies insisted on total openness, asking federal agents if minors were included in the transports. Investigators refused to reply, but verified that at least one car had been marked by immigration control during a prior halt, a report that was sealed without reason. Now that file was being unsealed as part of the broader inquiry, and another accusation under assessment was extortion, as witnesses claimed officers required fees to delay warrants. One clerk reportedly maintained a fee schedule in her desk, listing the price to erase a name from the docket at $5,000 and the cost to release evidence prior to disposal at $7,000. These figures were discovered in handwritten memos kept in binders that were nearly thrown out during the initial office search.
Attorneys were also getting ready to accuse multiple suspects of obstructing justice, which involved deleting video files, altering arrest times, and stripping tags from evidence. In a specific instance, the internal register indicated that a drug sample was removed for laboratory analysis, yet no results were ever submitted. Instead, the package was subsequently located within a private locker owned by a custodian at the courthouse, who is now being investigated alongside his immediate boss. The fourth significant accusation being weighed was the misuse of public office, a charge where intent was crucial, as detectives needed to prove officials used their authority deliberately to help felons evade justice. Scores of SMS messages, emails, and office notes are currently being organized for evidence, and one communication retrieved from a confiscated computer stated that the judge was away and the shipment should be sent that night. Prosecutors assert this text relates to a delivery that departed the Savannah warehouse just before midnight on a Friday, a cargo that never showed up in legal logs. Altogether, the Department of Justice has verified that more than 100 previous lawsuits are now being reassessed, covering a span of 5 years. These matters encompass narcotics seizures, racketeering probes, and murder trials, each possessing some odd characteristic that was ignored when it happened. Now those specific elements are being analyzed again to detect indications of interference. As evidence is weighed anew, video is retrieved from ancient servers, and witness rosters are checked line by line. The procedure will consume months or perhaps longer, yet officials insist there is no alternative, for once the bedrock of a court is doubted, every stone must be inspected. Meanwhile, demonstrations have persisted in growing across cities like Macon, Savannah, and Jackson, where civic heads are demanding federal supervision of regional tribunals. They are asking for a total audit of police behavior, political contributions, and court budgets, calling it a day of reckoning, while others view it as merely the beginning of a nationwide necessity. The issue now is not just who perpetrated these felonies, but how many individuals averted their gaze, as this inquiry has exposed the harsh reality that the cartel danger is not confined to the streets. It has penetrated the very organizations established to halt it, and the true peril lies in how profoundly rot can conceal itself behind a shield or a judicial decree. As fresh detentions approach and public testimonies commence, legislators might soon insist on changes to court safety, evidence monitoring, and digital supervision. However, beyond regulations, this matter acts as a caution that justice is not for sale, and the truth, regardless of how deep it is buried, will always emerge if someone has the courage to excavate. Until that happens, if you wish to be the earliest to learn when that boundary is breached, follow this channel to stay informed, because the instant the situation becomes volatile, you will receive the information here before anywhere else.